Mr. Gordon, good morning.
Good morning, Your Honor. I'm sorry.
How can I help you?
Yes, Your Honor, I believe that we're here on the status conference in regards to the Macee Lathers, State versus Macee Lathers. At
Page
the,
15.
yes, Your Honor.
Now, it's on behalf of the state.
Yeah, go ahead, sir.
Yeah, Your Honor, we're here because I know at the last hearing, Your Honor, told the state that the state needed to provide some kind of update on the phone dump. If Your Honor will recall, we were here in regards to the return of property in which our position is that the cell phones and the iPads should be returned. At that particular hearing, we stipulated according to the court's wishes, and we were able to resolve that. And now we're here to determine what's going on with the phone.
Yes, Judge, I approve the warrants. They were signed by a judge on February 13th for the detective. He dropped them off so that they can start the process. I was told that the extraction specialist says that it may take a very long time to get into these because it's a newer phone.
It's an iPhone.
It's an iPhone. I think it's the newer ones. They have like longer passwords, they're harder to get into. So who knows if we're ever going to be able to get into either the phone or the iPad, but both warrants were done and they were signed and they were submitted with the electronic items.
What reasonable range did they give you? I don't get familiar with that, know that it takes some time to go through a series of locks. Did they indicate 30 days, 60, 90, 2 weeks?
Basically what they do, my understanding, is that they put it onto this automatic device that continuously tries passwords until it actually finds the right one. It could take a year. It could take longer than that. I guess these new iPhones, unless there's new technology that comes, that's just unfortunately how it is. So it may be that we will never be able to get into this by the time that we have trial. I'm not going to delay the case solely as a result of this, but obviously if I can get the evidence, I want to. And so they have these devices on these electronic items and we're trying.
All right, so go ahead, Mr. Gordon.
Again, Your Honor, as we stated at the previous hearing, in the former affidavit that was provided by the state to the court, the state referenced in that affidavit, Your Honor, that the purpose of the extraction would have been solely to place her there at the vehicle at the time of the accident. Your Honor, they have ample evidence of that. They have video recordings from different street blocks. They have all type of video surveillance videos from witnesses that places her there. I think it's unreasonable for us to wait for an indefinite amount of time for them to return 2 iPads and a cell phone. I don't think that there's anything that would add to their case other than them just keeping the phone. And this is based on what they reference, Your Honor.
Judge Rickles, 1 iPad, 1 cell phone, 2, not any of the things that I said. If Your Honor recalls, what I stated is that I think that these items will tell us where she was earlier in the day. There is an element of substances and potentially alcohol as well as drugs that she ingested, which caused this incident. And so we wanted to know, she's an influencer, she was going to potentially bars and other locations, what else she was doing earlier that day. So that's what I stated we wanted those items for. As well, I just stated that I'm not asking to delay the case to get these items. I would love to have them, but if we are going to trial, everything else is done, and Your Honor is ready for trial and defense counsel is ready for trial, I'm gonna go without them.
All right, so Mr. Gordon, at this time, the motion for return of property is denied. I am going to make a finding that the iPad and the cell phones are of evidentiary value. Certainly, if they bear any fruit, Mr. Sy will advise you immediately in the form of a report. If they don't, by the time this case is ready to go to trial, the case will proceed to trial. Once there's no longer any evidentiary value because the trial has been concluded and or there's a final disposition on this case, those items can be returned. But at this point, the motion for return of property is denied. Let's talk about the status of this case, though. Ready discovery and when it's going to be ready for trial. I understand it's still somewhat young. It's approximately 6 months old. But where are we now? Ready discovery.
Judge, I've turned over quite a significant amount of discovery, videos, everything over evidence.com. I know that council has stated over and over and over again that he's having issues with the video, but we've sort of asked him what those issues are, and I don't really understand what the problems are because they all play for us. I think that the only thing that we are waiting for on the state side would be the final report written by the detectives.
The
I
lead
will try
detective's
to,
report?
yes,
Okay.
I will try to hurry the detective along.
All right, I'm gonna issue an
but-
order to compel 10 days on the lead detective's report.
Well, Judge, it's not in existence at this point, so I don't think that it can be compelled.
So what's the status of it? It's
He
been
has not,
7
I,
months.
he,
Did you
has
call
not-
him? Did you ask him how long it's gonna be?
not in the last couple of weeks. When I spoke to him on the 13th, when he texted me about the warrants, yes. And he stated that he is going to get moving on that and provide it as soon as possible. I don't know if he finished it and if it's in the review period, I would need to check on that.
All right, 10 days to compel and let him then explain to you that it's not ready. This is how long it's gonna be. I mean, they don't get just an indefinite amount of time to prepare these reports. And if you told me you spoke to him and he said that he's almost concluding it and it'll be ready in 30 days, 45 days, 15 days, but it's not just up to them to prepare whenever they get ready. So I am gonna issue the order to compel and maybe that will then generate a more definitive response as to when it's gonna be concluded and the status of the report. Mr. Gordon, you're able to access the videos now?
No,
Solve that problem?
no, Your Honor, we have not been able to access the videos. We've been going through this dance for quite some time in which I've alerted the state that I have had issues accessing the videos. There has been several attempts on our behalf to kind of get access to those videos. I even sent a list of the videos in which we were not able to access. I actually purchased another operating system, Your Honor, and I've tried on 3 different operating systems to access the videos, and we cannot access the videos. So I gave every name of the video. I emailed those to the state. I have been waiting for them to return the jump drive to me that I sent over a month ago with these videos, and perhaps there would be another avenue that we can get them open. And there has been no status, no update in regards to that matter. And so the state would simply say, well, can you tell us exactly why they won't open? I told them the error message that pops up when we try to open them. So at this particular point, we haven't moved forward for purposes of depositions because there are about 8 or 9 videos, if I recall correctly, that we can't see. And so I can't move forward without being able to view the evidence, and accordingly.
What else are you missing? What else are you missing?
Outside of the stuff that we're waiting for purposes of the detectives, I don't believe that we're missing anything. And of course, Your Honor, that's based on whether or not the state is saying that that's all that they have. So if the state is proffering that they have given me everything with the exception of whatever report they're waiting for the detectives, then I'll say that we have everything. Also, in regards to the cell phone, the iPad, Your Honor, we believe that there's some evidentiary value that may be significant for our case in chief. And so that's why we don't want to wait an indefinite amount of time for purposes of the return of that cell phone. Your Honor, I know that this is not your first dealing with that, neither mine. And I know generally there's a reasonable amount of time that those phones can be cracked. And so I just don't want it to be a situation where we're just waiting indefinitely so that we can see whether or not we can use any information off the phone ourselves.
Right, so here's the difficulty. Those items were seized by the police department, and so now they are in their custody. So that creates that difficulty. And it's not gonna be released until the case is concluded and or they've already extracted what they need. So it sounds like what you're telling me is that she needs what's in that.
She can provide the password. We're happy to do that. If she provides the password, we can get in.
Well, Your Honor, here's the deal. If she has an iPad and they're both Apple products, and this is the argument that we brought before the court, they're both Apple products. So essentially, whatever's on one iPad is on the iPhone. And so I don't understand why the state is taking a position saying that, hey, we want to keep all 3 of the devices when they're all interconnected.
There's
And
not 3, there's 2.
There's an iPhone.
One iPad and one iPhone.
According to my client, Your Honor, she believes that there were two iPads in the car. But even if that were the case, Your Honor, where it's one iPad and one iPhone, they're both Apple and they're interconnected. So whatever they would extract on one, they'd have it on the other. So what is the state's position while they're holding both devices?
Because both devices were subject to the search warrant. The search warrant was properly issued. It's at play now. Those items are in custody of the police department. And they're of evidentiary value. So I've already ruled on the motion for return of property. That motion is denied. If again, she believes that, and I'm not ordering her to do so, but if she wants to cooperate and sit down with law enforcement and they jointly go through those items, she certainly can extract anything that she believes is of exculpatory value for her. But, you know, to your point, if those items are in the cloud, she should be able to access those remotely on her own without the cooperation of the police department on the state. She can then buy herself a third device, go in her cloud, and she'd have access to anything that is in her cloud that would also jointly be shared by any of those items. So, so that's her choice. All right, this is what I'm gonna do. I do have to move on. Within the next 10 days, I want the two of you, I know Mr. Assad's gonna be in trial, to coordinate within a date within the next 30 days for the two of you to sit down, figure out where the difficulty is with the video, whether that means joint IT people get together, but some way ensure that you can get access to those videos. And I also want you to schedule a deposition dates. They don't have to be completed within 30 days, but certainly I want you to have that meeting within 30 days and set forth a deposition schedule and resolve the video issues. So I'm gonna set you shortly after those 30 days to make sure that has been done. April 8th will be your next status. All right, thank you both.